Hello friends, welcome to your own channel Knowledge of Justice. In this video, we will discuss a judgment pronounced by Jammu and Kashmir and Ladakh High Court in the year of 2023, which is related to Income Tax Act 1961. The title of this judgment is CIT versus DN Memorial Trust. So the case is, the trust had applied for registration under section 12AA clause 1 subclause B of Income Tax Act 1961, seeking tax benefits as a charitable institution. Thereafter, the Commissioner of Income Tax, Jammu and Kashmir, refused the registration, citing that the trust had generated surplus from its total receipts and thus did not satisfy the requirements of Section 12AA of Income Tax Act 1961. Then the trust filed an appeal with the Income Tax Appellate Tribunal Amritsar, which allowed the appeal directing the department to grant registration to the trust. The Commissioner of Income Tax, Jammu and Kashmir, then filed an appeal under Section 260A of Income Tax Act 1961, challenging the order of the Appellate Tribunal. The Honorable High Court, after considering the arguments and relevant facts, upheld the decision of the Income Tax Appellate Tribunal. The court emphasized that the Commissioner of Income Tax failed to provide any adverse material or evidence that the fees structure of the trust was against accepted norms or that the activities of the trust were non-charitable or for personal purposes of the trustees. As a result, the High Court found that there was no basis for denying registration of the trust. The court referred to a judgment of Supreme Court in Measures Queen's Educational Society versus Commissioner of Income Tax, which approved the test laid down in previous Supreme Court judgments to determine whether an educational institution exists solely for educational purposes and not for profit. The court reiterated that assessing authorities should continuously monitor such institutions to ensure they comply with the conditions for exemption, and their deviation should result in the withdrawal of approval and exemption. So, keeping all the relevant facts in mind, the Honorable High Court dismissed the appeal of the Commissioner of Income Tax, confirming that trust registration under Section 12AA of Income Tax Act 1961 cannot be denied merely for granting surplus profit as long as the trust activities are genuine and for charitable purposes. So, my dear listeners, the gist of the judgment is, trust registration under Section 12AA of Income Tax Act 1961 cannot be denied for surplus profit. For more videos, stay tuned with Knowledge of Justice. Thanks for watching.